Good evening, friends. This is a series now which I would be doing from my 76th video. I will be covering some judgments now of the Supreme Court, passed since 1910, but I'm taking the recent judgment of 2014, passed for a Bungalow 1A, Elphinstone Road, Pune. This bungalow was owned by Dinshaw, Shapoorji, Anklesaria and some others. Survey number 258, holding a property of 0.9 acres. Now this property originally was a grant given by G.G.O 14 of 1827. And the construction of the bungalow was done in 1891. So practically approximately after 60 years somewhat. 65 years. Now this property, as per the GLR, the name of the inheritant from Nusserwanji Sorabji Anklesaria went to Maneckhji Nusserwanji Anklesaria. So this property was allotted, as I just said, under the Governor General Order of 1827, and gradually it remained in the hands of the original owner. But in 1941, the original owner renders this property on a repairing lease to the Governor General. Now this is very important. In 1941, he is giving this bungalow to the Governor General, and this is all after the amalgamation of the three armies. So now the Governor General had no powers to take properties, and after the passing of the 1902-1924 Cantonment House Accommodation Act. Now very importantly, this property, it is written on the head note that this is not requisitioned under the Cantonment House Accommodation Act. Why? Because, unfortunately people in 41 or maybe in 2014 don't even know where this act and what does it speak of. This bungalow exchanged hands somewhere in 1968, November. And finally, it came to the present owner, Dinshaw, Shapoorji. And this bungalow was sold by the permission of the Ministry of Defence, given by an order of some June 1968 for an amount of rupees 60,000. Now, this new owner is finally giving an admission deed on 19th April 1971. I will read this admission deed in the end of this video. It's imaginable. You are giving in April 1971 an admission deed, and in June 1971, the department or the ministry realizes that let's resume this property. And for how much? Just 31,000 rupees. Half the price of what it was purchased by this owner. And the symbolic possession has already also been taken on 12th July 1971, practically after 30 days of the notice. Because this bungalow was on hire, now what was the condition is not known. 2 years later, the present owner decides to file in 1973 a civil suit for challenging the resumption notice. Now, it is very interesting. I will cut short. This present owner hypes on the entire findings and rulings of the P.T. Anklesaria case, which was from a writ petition which reached from High Court to the Supreme Court. And in July 1988, it was remanded back to the lower court, that is the High Court, for leading evidence in so many things. So what is it? In 1992, it very clearly said that the Bombay High Court said that the owner has already handed over the possession of the bungalow. So what lies in his mouth to file a civil suit? A review petition was filed somewhere in March 1992. Cases were transferred. The interlinking of two new issues were trying to be cropped up of ownership of land, building, and then landlord and tenant relations. So we were trying to get the cases into those civil jurisdictions now. Please try and understand. The lower court advocates and the legal luminaries of the Pune people were getting this case into a different rate. Resumption notice was one part, landlord and tenant relation was second part, whether the owner was the owner of the land or not, whether the grant could be resumed or a repairing lease could be. So these kind of issues were made. So finally, in 13th November 1995, the court allowed this review petition, and it very modified its judgment of the 25th March 92, and it says these degrees of eviction will not make the issues which have been raised in different appeals infructuous. So, but the resumption notice case shall continue because of a finding given in the P.T. Anklesaria case. Now, what did the learned Solicitor General said in that case? It said Union India would seek dispossession of the respondent occupants from the properties involved in accordance with law, and if need be, through a civil court by filing suit. In cases such steps are taken, any observations made by High Court which would stand to defeat the remedies would not stand in its way. On such stance, the Union of India Civil Appeal as also special SLPs stand disposed of. Accordingly, the court gave a finding on the statement of the learned Solicitor General. Now, the present owner of 1 Elphinstone Road in his lower court got some 7-8 issues under the resumption notices. Now, what were those issues? They were very simple. He was basically trying to prove whether he is the landlord and the department is a tenant. So, he's trying to get the repairing lease. Now, whether there was any breach of that repairing lease, because the property in that repairing lease had to be maintained by the MU or by the Governor General. So, many things had cropped up. The courts, even it came up that from 71 to somewhere 99, the rent was not paid of 196. So, these issues were made because of the pleadings made in that original case. Now, it is very interesting that there was a judgment decree passed on 9 June 2005. Against that, appeal was filed in 2006 in District Court, Pune, and the first appellate passed an order on 15th January 2009. Again, it dismissed the appeal. So, the lower court, the session, and finally, we went to the Bombay High Court, which also dismissed the appellate authority, dismissed the case on the same findings. We must understand, here it is very important, what are actually the government pleaders pleading in the courts. I'll read what he pleaded in this case. He again pleads under Section 2 of the Government Grant Acts of 1895. The TPA Act is not applicable on such government grant. Now, we have to understand, why am I being brought under a Government Grant Act? I am a grant which has a statutory force, which I just said in my earlier video, and which the courts have upheld, that G.G.O is a law by itself. So, when there is a law, how do I am covered under a grant? So, we'll talk about this in a later part. The second part, he says, it clears that the government grant is to take effect according to their tenure, with notwithstanding any rule of law, statute or enactment, or any legislature to the contrary of that, to the same. He is substantially getting us under the Government Grant Act. Here he even doesn't want to take that G.G.O as a statutory law. Union of India has unfettered discretion to impose any conditions, limitations or restrictions in its grant and rights. This is what he is trying to say. So, where are we trying to run? And then he says, the obligations of the grantee would be to be regulated only in accordance with the terms of the grant, which may be consistent, inconsistent with the provisions of the statute of the common law. Now, has the bungalow owner produced his original grant of 1827, or has the department? The government council even goes on to say that the owner does not have any relief in this writ petition under the Specific Relief Act of Section 6 also. So, he is not entitled to file any suit. Coming to the repairing lease, which he must have been owning in his hand, he is very clearly reading clause 4 of the repairing lease. It very clearly gives the government the right to resume the property during the lease period tenure going on. So, he says now when it was there, So again, your rights to the suit property are 0. Now, under this, he says, because of Section 3 Government Grant Act 1895, the Bombay Rent Control Act doesn't apply on these properties. So, where are we standing? So, this will not create any legal landlord-tenant relationship, as in other cases the properties in question fall in the cantonment area and are governed by the Government Grants Act. So, he is very clearly brought us purely under the Government Grant Act. So, we need to understand what is this Government Grant Act. Is it applicable on cantonment boundary pillars? Do we as G.G.O grants come under this? Whether this TPA Act statement of this Section 2 of the Grant Act says no properties can be transferred or are covered under TPA. So, nowhere our advocate, I think in this case, because I am going to read what my advocate or the advocate of the owner is pleading. Now, what is he pleading? He is not pleading anything what has been spoken by the Solicitor General or the Council of the Government of India. He is pleading that I am covered under the P.T. Anklesaria judgment of Supreme Court under the SLP, which has attained finality. Now, look at the travesty. So, in the absence of jurisdictional error committed by the courts below, the High Court was right in refusing to interfere with the concurrent findings of the fact. Because here the High Court had said we will not deal the case of resumption and ownerships or possessions. If I just said what was done by the review petition filed by this owner. So, the scope under the Section 115 of CPC is limited, and the same cannot be exercised or interfered. Now, look at, just see where we are reaching. Friends, I am very categorically saying the High Court approach in analyzing is correct under Article 136 of the Constitution. So, this part of the judge impugned order is correct. That's all. Nothing has the advocate spoken of G.G.O 14 of 1827. Neither has he speaked why Grant Act is not applicable on us, why TPA Act under the CLA rules 1925 or 37 stand applicable on us. Now I will read that 1971 admission deed which was made to be signed by this owner. I will read this. This is something very interesting. For the first time even I have come across an admission deed something like this. It says in para 1, permission to occupy ground in military cantonments, confer no proprietary rights. It continues, it is continuous to the property of the state and presumable at the pleasure of the government, but in all practical cases 1 month notice of resumption will be given, and the value of all buildings which may have been authorized to be erected thereon by a general plan estimated under the committee contemplated by the Governor General Order of 1856. Now, he says G.G.O 14 of 1827 doesn't have a contemplation that it has to be compensated, but a separate G.G.O was made in 1856 for Bombay Presidency, that no buildings are to be erected on the ground other than those now existing and shown on the attached plan, no addition and alterations without the permission. The ground being the property of government cannot be sold by the grantee. The building may be sold by house owners of the previous permission again of the Commander-in-Chief. Military authorities have the power to cancel the grant if the ground is used for any purpose other than what it was originally granted. We also agree to abide by any order and rules that have been passed regarding tenure of lands in cantonment. It is surprising. If 71, this is the admission deed given. Friends, please, let's have local associations, but create local legal cells. We don't even know how to counter an admission deed where it came in 1937 CLA rules that an admission has to be taken from a B3 landowner and why it has to be taken. So this is something which the department takes for mutation. Nowhere the G.G.O speaks of something like this. So there are so many things. So let's try and educate our local advocates. let us create this, because he is not speaking anything of the Governor General Order of 1856, which is printed in the MLM. So there are so many things, but this judgment is so disastrous. You know what the order is pronounced? Form the permission of sale of property letter dated so and so, indenture of sale deed dated November 1968, and the admission certificate of April 1971 signed by the owner. It clears that the military authorities have the power to cancel the grant if the land is used for any other purpose than it was originally granted. Wow, this is amazing. This order is that this owner, a bungalow which has been hired, he has misused his grant for a purpose given to him in 1827, and he had not been doing it. He was not in the symbolic possession of the property. Most astonishing. This judgment foresays and it challenges that civil appeal of 1980, which was heard. Orders given by the Solicitor General would seek dispossession of the respondent occupants from the properties involved in accordance with the law of P.T. Anklesaria. The court pronounces in this judgment the liberty given to the Union of India to dispossess the plaintiff respondents for the suit property clearly indicates that the decision of the Bombay High Court that the suit premises do not belong to the Union of India not acceptable to the court. So everything goes flat. All efforts are washed away of the 1980 P.T. Anklesaria judgment. Friends, we need to educate our lawyers. Come on, just wake up. Otherwise, we will have no chance. All these mistakes, I can rebrush the list of mistakes, which will be uploaded on my website, because I will not be making my videos very lengthy. So all the parts which the local advocate or the evidences should have been led, I'm going to put them on my website of this particular case. Once again, I'm saying we are old grants. We were paying no revenue to the British government because we were not converted into new grants. Since 1765, 1790 or 1812, culminating in 1859. Please, I'm with folded hands saying, bring your neighbor, get your local advocates educated on these subjects. Thank you. Good night.